Hi, Jason Kohlmeyer, Rosengren Kohlmeyer Law Office, Mankato, Minnesota, answering your weekly divorce questions. This week's question is what is the process of a divorce if it actually goes to trial? That's a hell of a question. That's just a fantastic question because nobody really asks that, and what happens. Well, first off, let me tell you, family law divorce, you don't have a jury. This is just to the judge. It is always to the judge. You don't even have an option for a jury in a divorce case. And so what happens is the petitioner goes first. The one who wants the divorce will be the first one to go. There sometimes is an opening statement, but not always. And then the person who wants the divorce will present evidence. And it usually is the petitioner talks. Sometimes then they will have a family member, sometimes a new significant other, some other witnesses to either talk about the assets on the case or on the children, how they want to divide that up. And usually at the beginning of the case is when the custody evaluator does their thing, meaning that they testify to the judge as an expert. Once that's done, then the respondent has the option to go. And then the respondent will present their evidence and say, oh, everything you just heard is a bunch of crap, typically. And they go back and forth. You have a right to cross-examine witnesses, but everybody takes the stand. A divorce trial is a real trial. It's not a pretend trial or a semi-trial. It is under oath. You stand up and you get sworn in, raising your hand that you're going to tell the truth. If you lie, it's a felony, it's perjury. And so it's a big deal. It's an open forum. Anybody can go and watch the case, and sometimes they do. And so when some people say that they're going to go to trial, they may not really understand that just about every trial, divorce trial, is a day long. One thing I should mention, though, that the judge does not issue a ruling at the end of the divorce. I've been doing this over 14 years, and I've had it happen one time. That was a unique case when the judge retired after my case. I was the last case he'd ever heard, and he issued an oral ruling. Normally what happens is we don't do closing arguments like you see on TV. There isn't any of that. What happens is we finish, and then the judge gives us each lawyer 30 days to put in a written request for what we want the judge to sign, or what we call a proposed order. Once the proposed order is submitted, we also submit what's called a memorandum of law, and that is really the argument to the judge that you would be familiar with on TV, closing statements. The judge reads both of those, picks which order he or she wants to sign, and signs it. And that's about it. And the problem, I will say, is that after the trial, you're looking at 90 days before the judge has to issue a ruling. And after a trial, they nearly always take the full 90 days. So if you think you're going to go to trial on September 1st and you're going to be done, and you just want to be done on September 2nd, you're not going to be done until December on that. So it's going to take quite a while. There you go. I hope that answers and sheds some of the light on what is a divorce trial. Jason Kohlmeyer, Rosengren Kohlmeyer Law Office, Mankato, Minnesota.